Welcome back you all to the lecture series on corporate law. The lecture 9 is devoted to the concepts, interpretations and analysis on transfer and transmission of the shares. In corporate law and also in capital markets, the subject of transfer and transmission of shares is very important, where you find the huge litigation and the rights as well as to the liabilities of two parties, that is, one who is the transferor, then the other one is the transferee. Because the Companies Act in detail explains, elucidates and also discusses the procedure for transfer and also with regard to the transmission. Let us try to understand what is meant by transfer and how this transfer has importance of the legal concepts. I try to briefly put it in this flowchart. Transfer of the shares, otherwise called transfer of the shares, or we call it as a transfer of movable property, because shares are considered as movable property according to the Company Law, Transfer of Property Act, as well as to the Sale of Goods Act. Kindly remember, shares are movable property. The transfer of the shares is, the mode for the transfer of property, particularly for these movable properties, is same applicable to the shares. Now another fundamental question comes, what do you mean by transfer? Is it a transfer of ownership or transfer of the possession? I try to explain in a simple way, where you try to transfer completely the ownership as well as the possession also, right? We put it in the simple concept of sale. Every one of us know there is a concept of the sale. That means A is the shareholder, A transfers to the B, and if A is the transferor, right? A is the transferor and transfer to transferee, and after that A will hand over the shares to the B and B will have the right over the particular movable property. To understand this particular concept, I am trying to explain in a simple hypothetical examples, because the transfer of shares is a practical subject where you find the day-to-day litigations, where you find lot of issues arising before the court of law on the rights of the various parties. Let us take a simple example. X Limited Company. I am taking example of public limited listed companies, right? X Limited Company. You have, say for example, 500 members held 500 shares. So I have taken a simple example. X Limited Private Limited Company is having the 500 members and also the 500 shares. In this example, I am taking the members of the shares or the shareholders are E, F, G, right? So you have 7 members who are having the shares. If you take an example in this way, the X Limited Company, you are followed by 500 members having the 500 shares and followed by different members. Now let us take an example. Mr. D is having 10 shares and D wants to transfer to X, who is also a third party, right? Mr. D is purchased the shares from X Limited and D wants to transfer to the X. This is the relation between D and X, right? X is the seller, B is the buyer. If there is a transaction between the sale, the document is drafted as sale deed. It's a simple understanding of corporate law. D wants to sell to X some of the shares. I will put in a simple example again. In the X Limited company, D is the shareholder. D is having the 10 shares. D wants to transfer to the X. So the relation between the D and X is buyer and seller. Now in the same case, D wants to sell only 5 shares and retain the 5 shares. So X purchases the shares. Now X has to make an application to X Limited whereby the name of the X is entered into the register of what you call the shareholders. So now X is holding the 5 shares. After some point of the time, X want to transfer to the Y and Y want to transfer to the Z. The example which I want to try to explain is that where you have the multiple transfers, where you find about transfer of the shares from one party to another party in the capital markets, in the securities market. Now the question comes, what is the law governing? What are the instruments it can be drafted? I try to explain the same example in another way of understanding, right? The understanding of the example in a simple way, that is, in the case of the X also made a transfer to the Y, Y made a transfer to the Z. If we take an example of Y is transferring to the Z on mortgage, or otherwise called on the pledge, because pledge is also a very important concept in the mobile property, or hypothecation, right? So pledge and hypothecations. When you look about the pledge and hypothecation, they are only transferring certain rights from Y to Z, certain rights among the Y and Z. So this is what we understand in Companies Act, the transfer of the shares in the listed public companies, where transfer of the shares happens with multiple parties over a point of time, right? Over a point of time when it comes to the transfers. I try to reiterate again, transfer includes various modes of the transfer. One of the mode of the transfer is a sale, right? So when there is a sale, you can understand the transferor will leave the company and the transferee will get the shares, and transferee make an application to the company wherefore his name is being entered. The other types of the transfers which I put it here is called hypothecation, pledge, as well as to the lien. So these are also called as the various types of the transfers. Now let us see the provision of Companies Act. To make it very simple, I will come back to the flowchart again. When the movable properties are being transferred, and these movable properties are being transferred in a simple understanding of the concept, right? Or in the legal analysis, the two important concepts which is very, very debatable, which includes the complete practice of law, that is transfer of possession, transfer of ownership. You have an examples of pledge and hypothecation and the lien. These are all the legal concepts which you find very frequently on the transfers. Now let us read from section 56 of the Companies Act. Section 56 of Companies Act talks in a broader terminology, transfer and transmission of securities. My dear friends, I am again telling, transfer and transmission of securities. Section 56 is not just confining to the transfer of shares. It is confining to the transfer of securities. Now, I am trying to again explain, securities include, according to Section 2 Clause H of SCR Act 1956, shares, debentures, right? You are having the mutual funds, you are having the venture capital funds, ADRs and GDRs, all comes under the definition of the securities. So securities is inclusive of various financial instruments according to the Securities Contract Act 1956. Try to remember, section 56 comes to you the practical aspects when you read about the what is meant by the transfer. Let us see section 56. Section 56 says a company shall not resist a transfer of securities of the company or interest of the company has no other than the transfer between of the persons, both of whose names are entered as the beneficial interest in the registry, unless a proper instrument of transfer in such form as may be prescribed. Now, I will dissect the provision. What the provision says? The provision says it can be transferred between the two parties where these two parties prepares a proper instrument of transfer as prescribed under the company law. The proper instrument of the transfer is again legal terminology. Now let us see what is the meant by proper instrument of transfers. When you look about the proper instrument of transfers, so proper instrument again I am putting in a simple understanding, that is, say for example, sale deed, mortgage, pledge, hypothecation, lien. All these documents we can give an examples called a proper deed of transfers or a proper instrument of transfers. Kindly remember, transfer of possession, transfer of interest. In the case of mortgages, there are some types of the mortgage where you see a transfer of only interest, In the case of transfer of interest, the ownership of the property is enjoyed by the transferor. Transferee only enjoys the fruits of the particular property. The fruits of the property means the returns which arises. What are the returns which arises in the share transfers? The returns which arises in the shares is that, or in any one of the documents is that, one is about the dividends, other one is about the interest. There are two returns for any investments in the capital markets or in the normal course of investments. So the two returns are, one is about the interest over a property, second one is about the dividends. For example, if there is a debt capital, or otherwise called if there is a capital of the what we can say share capital, the interest on the or the returns on the investment of the share capital is the interest, or the debentures is the dividend, and depending upon the nature of the instruments, like in the securities includes both the debt capital and equity capital. When you talk about the equity and debt capital, the returns for the equity capital are basically interest. The returns for the debt capital are the what to call interest, and equity capital is the dividend. In a simple way to provide our understanding of the transfer of the shares are that the agreements, the instruments which are drafted between the parties, and it is up to the parties to decide what type of instrument, what type of agreement is being decided. Now in this practice, it is necessary to understand the important nature of the documents. It can be a pledge, it can be hypothecation, it can be a mortgage, it can be a sale or a conditional sale, so lien. So you have the charges, so various draftings or the instruments are being created. So now let us see again section 56. So section 56 comes with the concept, the transfer which comes under a proper instruments. Hope you are clear what is meant by proper instruments. Proper instrument again comes as the legal agreements or otherwise called legal instruments. Now, second one, the important concept, whenever there is a transfer of the shares and the deed of the transfer should be duly stamped. Here you read the most of the practical term today called as STT. What is this STT? Securities Transaction Tax. If there is the transfers on the shares or the securities, so STT becomes very important when there is a transfer of the shares from one party to the another parties. So the simple concept, if there is the transfer of the shares between the transferor and the transferee, transferor is the one who transfers, transferee is the one who receives. They can enter into the different agreements. However, they enter in a different agreements, they should provide the stamp duty, otherwise we call as the securities transaction tax, followed by the proper instrument of transfers. So company law has given a scope to both the parties to write the name or to understand what type of instrument they want to develop. This is one of the gray areas of corporate law, because company law has given a scope to the parties to draft, to identify the nature of the instruments, because it is end of the day wisdom of the commercial persons, wisdom of the commercial men to understand what type of instrument that they want to draft, because it is again silent. Irrespective of the nature of the document, then they are supposed to pay securities transaction tax and proper instruments. So two legal concepts under section 56. The first one is proper instrument of the transfers. Second one is the stamp duty. Otherwise we have the STT, securities transaction tax. Any transfer of the shares will arise as the tax. The evasion of the tax will lead to the lot of disputes. That is why we have another case, the very famous case, Vodafone Holdings 2012 Supreme Court judgment. I will be taking a special class on Vodafone tax law. So the whole issue of the Vodafone case is about the transfer of the shares from one country to another country, which arises later part of the time, payment of the tax, where there is an avoidance of the taxes. The whole issue became a subject matter in the different adjudicatory bodies, in the different jurisdictions where there is the different adjudicatory bodies. The third important, it has to be executed by or on behalf of the transferor and the transferee, specifying the name, address and the occupation if any, and the transfer has been delivered to the company by the transferor or the transferee within a period of 60 days from the date of execution. So they provided among the two people a 60 days of time after execution of the document, where the transferee will make an application to the company, kindly add my name in the share certificate. Because share certificate issued by the company, the transferee makes an application after receiving of a certificate, original certificate from the transferor, and on the basis of that particular certificate, the names will be changed. So they provided a time of 60 days and therefore they try to transfer the name of the securities. They may apply immediately and they may also apply within a day or 2 days where the transfer of securities are given, because the thing is that certificate of the shares issued by the company determines the ownership of the shares, right? If a person is having the certificate of the shares issued by the company, it determines that who is the owner of the shares. Once the ownership is being transferred from transferor to the transferee, and the transferee have to make application to the company, because company ratifies, company changes the name of the transferor name to another transferee. That means if Mr. A transfers to the B, now B will make an application to X Limited, and X Limited will issue the certificate in the name of the B. Originally, the shares of X Limited are held by the A, and A made a transfer to the B. Now B become the owner. B make an application to X Limited. X Limited will correct the names of the certificate. Now you will get X Limited issues the share certificate to the B, justifying B is the owner of the shares. Now some of you may have a doubt. Sir, where the sale and purchase happens on day-to-day basis? Because I will purchase the shares now. Within half an hour or 1 hour, I will try to sell today itself. Now the question will come, if there is a transfer of the shares on daily basis, who is the owner of the shares? When there is a transfer of the shares on daily basis, we have name, or we have already seen the name which is entered in the beneficial owner. Because every transfer of the share, every transfer of the share, the transferor name will be changed by the transferee name in the records of the depository, right? So we have the depository. The names which are entered in the depository, we call it as beneficial owner. So initially, on the day when the transfer happens, the owner becomes a beneficial owner. After complete transfer, that means the beneficial owner will make an application to the company after receiving of a certificate, then the name will be changed. So this is a technical process, because this is the process which involves some time where the original certificates will be replaced by change of the names. So that is again a process will come where the transferee will make an applications. Otherwise, in a simple way of understanding the Section 56 of the Companies Act, Section 56 of the Companies Act provides transfer of the shares, in the transfer of the shares among the transferee and the transferee. Now let us move on to another example which I want to put it. The first example which I have taken is about the public limited companies. In the public limited companies, what happens, like, let me erase and see. Because public limited companies, transfer of the shares are very freely transferable. In the case of private limited companies, they are not freely transferable. So that is where we find lot of disputes on the corporate law. Now let us see about the, right? Say for example, X private limited company. In the X private limited company, you have the shareholders A, B, and C. There are 3 shareholders in a private limited company. Now let us try to understand the corporate law, fundamental basics of corporate law. The shares in public limited companies are freely transferable. When you read the company law, the definition of the private limited company, it says shares in private limited company are not freely transferable. You can have as many restrictions you want. So what are these restrictions? Let us have an example. A is willing to transfer to the B on a condition. If the B wants to transfer to the C, B should offer to the A, right? I will repeat again. A is the owner of the share. A wants to transfer some of the shares to the B on a condition. If at any point of time B wants to tell to third party, or B wants to give to another party, B first offer to the A. This is what we call this as one of the restrictions on transfer of the shares that is called as first offers, right? Right of first offer. We call it as right of first offer, or ROFR, or right of first refusals. Because in private limited company, the transfer of the shares are being restricted. If it is among the shareholders, there are a lot of agreements, lot of clauses which we find in corporate law, or which we find on the transfer of the shares. We find about the different clauses are being done. One of the clause which happens in private limited companies, among the group of the shareholders, among the members of the shareholders, they may have the varieties of clauses, and the clauses are given to the people who are deciding about the what type of right. Because a lot of jurisprudence has been developed on the transfer of shares, particularly the clauses in the transfer agreement. What is the clauses in the transfer agreement? Because transfer clauses in transfer agreement requires for me to explain maybe another 40 to 50 minutes. So I will be recording another lecture on clauses in the transfer agreement. The point which I want to put it here is called transfer of the shares in the private limited company are restricted, whereas transfer in the what is called about the public limited companies, right? Transfer in the public limited companies are have the different understanding. What are the transfers in the public limited companies? Are the transfer in public limited companies, shares are freely transferable. Because that is very important to understand. Otherwise, what will happen is that we try to understand very, very confusing way. The confusing way is that the people who are owning the shares, they want to control the company. They want to have a control always in the company. When they wish to have control over a company, one of the group of members of the family, they try to hold the control always. This is again comes as the another byproduct of the transfers. Now let us see about this particular subject which we call as the transfer and transmission of the shares. When you find the transfer and transmission of the shares, now under section 56 of the Companies Act, the transfer includes interest of the member in the transfers and also the name where there is a beneficial interest or beneficial owner. Another important concept in transfer, using of the proper instrument of transfers. Now moving further under section 56, right? Section 56, first concept we talk about the transfers. Under section 56, we talk about the transmission. So what is meant by transmission? Transmission, I try to put it called by virtue of law. What is this by virtue of law? Now let us have an understanding like what is meant by transmission. Like just a minute, we will put it on this slide. A is having the shares in X Limited. In the case of A died, the shares will automatically goes to the his legal representative, otherwise called as the nominee. If there is a B is a nominee, on the death of A, right? On the death of A, the shares of A automatically will flow to the B. Number one, on the death of the person. Number two, by court orders. Number three, when he becomes insolvent, automatically by taking the course called by virtue of law, right? By virtue of law in the sense that we don't require the transfer has to be made by company itself, because the legal representatives, nominees, insolvent people, the shares will be going to the one party to the another party. So this is what we call in the simple understanding. In the case of the transfer of the shares or the transmission of the shares is nothing but of shares which are being transferred by virtue of law. So try to understand, by virtue of law means where the provisions of law it is being transferred. Now let us see the provision. Transmission of the shares means without prejudice to the subclause number 1, the power of the company to register a receipt or intimation of transfer of any right of securities by operation of law. Right? Transmission of any right to securities by operation of law from any person to whom which right has been transferred. Right has been transferred by operation of law. This is what I have given a simple example. Mr. A, in the death of Mr. A, it will go to the nominee, otherwise one is the nominee, second one is a legal representative, right? If there is a dispute between a legal representative, then there is another court litigation will start, because this is also very important practical subject. Because for example, let me take a small example. Mr. A is having like B and C wives, and there may be a dispute who is the legal heirs. Though Indian law prohibits in some of the communities having the more than one wife, polygamy is not permitted, particularly in the Indian Hindu law. But if Mr. A is having, and if there is a question of the marriage itself, then who becomes the legal representative? And afterwards, then if he has a children and other people are there, in the sense called children and other relatives, the dispute comes entitlement to, right? Entitlement to movable property successions. So on the death of the person, what is that entitlement of the movable property rights? Who has the succession? So this is where you find number of cases, right? Number of cases on the jurisprudential aspects, or the where court has decided, right? Court has decided to talk on the what is called the rights. The court has decided about the legal implications on the ownership of the shares. So the ownership of the shares with regard to the transmission always happens by operation of law. I am writing here by operation of law. Kindly remember this particular term, which has a lot of interpretations. Now, where an application is made by the transferor alone and relates to partly paid shares, the transfer shall not be registered. Right? The very important subclause under 56 is that the transfer only happens with regard to the fully paid up shares, not the partly paid shares. Unless the company gives the notice of application in such a manner as may be prescribed to the transferee, and transferee gives no objection to transfer within 2 weeks from the receipt of the notice. So generally, the rights with regard to the transfer of the shares and the ownership of the shares, they provided on the who has the what is called the fully paid shares. In the case of partly paid shares, the question will come about the liability will also transfers. What happens liability of the shares when the company makes the sale, when the company makes the calls, the transfer is supposed to pay the unpaid share capitals. So that is again comes on the another important. Now let us discuss, right? I will try to introduce you section 56, class number 4, and some of the procedural aspects. We started our lecture, section 56. Now under section 56, subclass number 4, we are discussing. Every company, unless prohibited by provisions of law or by order of the court, tribunal or authority deliver the certificate of all securities allotted, transfer and transmission. So remember, three aspects of transfers are discussed in company law. The first one is allotment of securities, transfer of securities and transmission of securities. For all these aspects, section 56 clause 4 comes. Every company, that means it applies to the public company, it applies to the private companies. So unless prohibited by the provisions of law or by any court order, the tribunal or any authority, it has to deliver the certificates of all securities allotted, transmitted and transformed within a period of 2 months from the date of incorporation in the case of subscribers of MOA, right? Again, the fundamentals of company law has come back. If the A Limited is incorporated, say for example, 24/10/2022, within 2 months means, right, 12/2022, right, 23. Within 2 months, it has to give it to the subscribers of MOA. So that law provides the 2 months duration for the allotment of the shares. Within a period of 2 months from the date of allotment, in the case of any allotment of any shares, within a period of 1 month, receipt of the company instrument of transfers. This is again comes a transfer of the shares, right? A transfer of the shares, what they want to meet. In the case of transfer, they are bringing with regard to the 1 month time. So as the case may be provided. Now in the case of the transmission and also the transfer and transmission of securities. So they provided for you is the 1 month time with regard to the transmission of the shares as well as transfer of the shares. For the first allotment, 2 months. After that is the 1 month. These are procedural aspects where one of the party has to make an application, where the party, when the transfer happens, that party will approach to the company, kindly allot for the shares, and therefore the share certificate's name will be changed. The transfer of any security or other interest of deceased person of the company made by a legal representative shall, even if the legal representative is not a holder thereof, be valued as if he had been the holder at the time of execution of instrument of transfer. So section 56 clause 5 talks the transfer of any security or interest of the deceased person in a company made by his legal representative shall, even if the legal representative is not holder thereof, be valid as if he had been the holder at the time of execution of instrument of transfers. So this is again another important clause for the transmission of the shares. Now there are various case laws on the transfer of the shares. One of the cases V.B. Rangarajan's case, M.S. Madhusudan versus Kerala Comedy Private Limited case, because this is also a very interesting case which talks about the family agreements, whether that can be enforceable in private law or private agreements or not. Then what is the legal sanctity of the shareholding agreement, right? Shareholding agreement is a agreement between the some or all the other shareholders for the purpose which is conferred to the imposition of obligations. And SHA is a flexibility under the Articles of Association, because SHA, in the shorter form of the agreement, is the SHA talks about the various rights and agreements. Now, I just want to confine this lecture only with regard to the section 56, clause 1, 2, 3, 4 and 5 on the simple understanding of transfer and transmission, right? In the next lecture, I will try to put it clauses in transfer agreements as well as transfer of various modes, and also discussing about the case laws, right? Case laws on shareholding agreement and the share subscription agreement. So I will try to take another lectures on the MS Madhusudan's case, VB Rangarajan case, Vodafone case, what is the shareholding agreement, as well as with regard to the share subscription agreement. This lecture is mainly to make an understanding of transfer and transmission of the shares. So I try to introduce you to the basic understanding of the transfers and the transmission. Transfer includes the various modes, transmission by virtue of law, and the legal provision is transfer and transmission of securities. I will repeat again, transfer and transmission of securities is given under section 56. Don't get confused, transfer of the shares and transmission of the shares. In the 1956 Act, it is there transfer and transmission of the shares. In the 2013 Act, it has made very clear that is transfer and transmission of securities. Securities again importantly includes all the financial products and financial instruments of the corporate law. That is under the Securities Contract Act, section 2, clause H. So this lecture is basically to introduce to the transfer and transmission of shares. So listen very carefully and try to understand. If any doubts are there, kindly write in comments. I will try to provide the answers in the further lectures, right? So thank you for patiently listening the lectures. Take care, bye. And next class, we'll talk about the shareholding agreement as well as share subscription agreement, case laws, and other subjects or other concepts of the share transfer agreement. So thank you, one and all. Take care and bye.